Good morning, children. How are you? Okay. So today we are going to continue our topic, different roles of the Supreme Court of India. We have started yesterday, and we discussed till its advisory jurisdiction. Presidential reference means where we have finished yesterday. As a conclusory remark, it was Article 143 of our Constitution. Fine. Before going to proceed, whatsoever we have discussed in this chapter, in this unit, judiciary, apart from the structure hierarchy, we have discussed about Supreme Court. Their different rules right now we are discussing. Then we discussed about High Court, we discussed about Supreme Court, not to mention about tribunals. We discussed about the salient features of our judiciary. We discussed about Attorney General and other law officers, including Advocate General, independence of judiciary, and in this different roles of the Supreme Court of India, we are going to continue our discussion that apart from the presidential reference, or so far what had been discussed by us, okay, that the constitutional imperatives, we have seen the constitutional imperatives are there that permit the Supreme Court to adjudicate and advise on disputes that arise, that come out from the subordinate court. Individuals they do have their rights. So individuals exercising writ jurisdiction. About writ we have discussed in detail, children, in last class also, and in our previous class also we have discussed the kinds or types of writs, and even the President of India. So constitutional imperatives that permit the Supreme Court to adjudicate and advise on disputes that come out from the subordinate courts, from the individuals, those individuals who exercise their writ jurisdiction, and President of India, not to forget about the President of India. Fine. Now, what in the recent past, in the recent years, what had been observed by us that the Supreme Court has relaxed its locus standi. Now you'd ask, what does this term locus standi means? Yes, locus standi means the right of a party to appear and be heard by a court. Suppose I want to appear in the court, I want to plead my case, I want someone else to plead my case. Okay, so every individual, they do have this right. So we say the right of a party to appear and be heard by a court. Court must hear even a locus standi. So Supreme Court has relaxed its locus standi, means the right of a party to appear and be heard by a court, and has permitted public spirited citizens. So many of us are highly social. So those public spirited citizens and the civil society organizations, that they can approach the court on behalf of the victims. Victims are uneducated, illiterate, disadvantaged group of our society. Okay, so for those people, on their behalf, on behalf of the victims, for better administration of justice, so that they can also enjoy, they could also get the justice in their favor. Okay. Now on the other hand, on other accounts, the court, this is the one aspect. Now on other accounts, the court has on its own initiative, court started taking initiatives on its own, started cases of public importance. Okay, on its own, court started cases of public importance, like court has summoned and reprimanded state authorities for their apathy, for their lack of diligence, means for their carelessness, for they are not taking proper care in running child care homes in the states. We do have the shelter homes, we do have the child care homes, we do have the orphanages. Okay, so for all these cases, and particularly here the carelessness in running child care homes in the states, court has summoned and reprimanded state authorities that they are not concerned, they are losing their concern, they are minimizing their concern, and all this has been possible through the judicial activism. Yes, children, all these had been possible through judicial activism of the Supreme Court of India. Okay. So, judicial activism of Supreme Court through public interest litigation. Okay, what we say, Lok Janhit Yachika or Janhit Yachika PIL, popularly known as PIL. So, this is an extraordinary jurisdiction that has been invoked either through writs or even by writing letters to judges. Even letters can be written to the judges. Okay, letters can be written to the President or Prime Minister of India. Here we are confining ourselves that letters even can be written to the judges. Okay. So, letters can also be written whose modalities are maintained under the guidelines for PIL enacted by the court. Okay, and their complete modalities are maintained whatsoever guidelines have been given by the court. In this PIL, children, PIL is a very important concept. Now, we must know about the first ever PIL. The first ever PIL, yes, that is the year we need to go back to the year 1979. Fine, and the state once again, state of Bihar. Okay, the land of Gautam Buddha, the land of Mahavira, the land of Ashoka, the land of Chandragupta Maurya. These all important personalities, they have taken birth here on this land. So, it again started from the state, in the state of Bihar, and that PIL is known as Husainara Khatun versus state of Bihar. What was the case? Here, a public interest activist lawyer filed this case, a case on behalf of thousands of prisoners of the Bihar jail. So, for the thousands of prisoners of the Bihar jail, a public interest activist lawyer has filed this case against the inhuman conditions being faced by these prisoners in the prison. Fine. So, Supreme Court started hearing the case, and the Supreme Court bench headed by Justice P. N. Bhagwati heard and then finally gave the verdict, declared that right for free legal aid and expeditious trial of these prisoners. These prisoners, they do have the right of a free legal aid and expeditious trial, and as a result it led to their release. They had been released from the jail, from the prison. Since then, PILs have encompassed, have gone through several issues including socio-economic conditions, socio-economic rights, that may be the somebody's freedom from the bonded labor, someone is forced to do this work, legal entitlements, right to food, right to work, right to shelter, environmental issues, clean air, clean water, political reforms. Those political reforms like disclosure of assets by members of the executive. Everybody need to disclose their asset. Disbursement of natural resources, what had been done by the government. About all those issues, in fact, children, PILs can be filed. Okay. Now, with the progress of this PIL, what has happened actually, children, that you must know, with the enactment of this or this system, the way it started, okay, with its process, okay, and the entire progress, it seemed the progress of PIL seemed to incorporate several issues. Some common characteristics encompass these litigations, and these common characteristics include: number one, that PILs can be termed as non-adversarial litigation. Okay, non-adversarial and adversarial and inquisitorial we have discussed. Now here it is non-adversarial litigation. Okay, and under this non-adversarial, why do we say that, or why had it been termed as non-adversarial? It pits the interests of one party over the other. It keeps the interest of one party over the other. Rather than focusing on traditional litigation of adversary character, one must focus on the traditional litigation of adversary character, opposite character. PILs are recognized as tools for social change. So, certainly, PILs are recognized as a tool for social change, undoubtedly. Okay. Number 2, these PILs are based on tenets of citizens' standing, and representative standing, which expands the rights of third parties to approach the court. That third parties, the way they want to go to the court. So these are based on the tenets of citizens standing and representative standing. Here we are having someone else who represent one entire group. Okay, so citizen standing or representative standing, which expands the rights of third parties to approach the court. Fine, children. Number 3. Under this, what do you find? That PIL since its inception, since beginning, is modeled on remedial nature, means which aims at creating a dynamic, welfare-oriented model of judiciary. A dynamic model of judiciary and welfare-oriented model of judiciary. And thus we can say that PIL incorporates the directive principles. Okay, I hope you must have recalled the directive principles of a state policy. So PIL thus incorporates the directive principles whose claims cannot be brought directly to the courts, into the domain of fundamental rights. As we know, under part 3 of our constitution, we do have fundamental rights which can be invoked before the courts as a matter of right by the citizens of India. In case of violation of a fundamental right, directly we can approach to the court, but in case of violation of directive principles of state policy, we can't directly go to the courts. Therefore, PILs are creating new rights and new laws within the realm of the state. And these laws are also democratizing citizens' access. We are getting the scope of our rights expanded. Okay, we are living in such a democratic world where every facilities are being offered to us. So we say it that these laws are also democratizing citizens' access to justice and thereby strengthening the democracy in India. In this way, PIL has strengthened the democracy in our country. Okay. Number 4, that PIL further strengthens the role of judiciary. How come and how does it do? PIL strengthens the role of judiciary as a monitor and a watchdog agency. As we discussed earlier also, in case of any dispute, Supreme Court or judiciary, they can interfere in the functioning of the government. They can tell the government and different organs that you need to follow your limit. You need to be in your limit only. You don't need to cross your limit. Fear of being dragged to the court via or through PIL has improved the quality of several social institutions in our country, such as jails or mental asylum or protective homes or several other such places that are there to improve the overall condition of our society and to maximize the facilities given to we, the people of India. However, with the advent and growth of PILs, they have also been misused. They have also been misused for private gains. Sometimes the negative news also we get that for private gains, for petty gains, it has been misutilized and led to frivolous litigation on unnecessary issues, the issues that are not important, the issues that are of least importance, the issues that are of no public importance, that are also being filed under this or by misusing the provisions of PIL. So, they have also been criticized for judicial overreach and stepping into the shoes of legislature. So, judiciary can never find itself into the role of a legislature, but wherever it is a compulsion, or judiciary is just like, as we discussed, as a monitor and watchdog agency. Fine. So, for the sake of the monitoring, for the sake of keeping an eye, so that the people in legislature, the people in executive, they must not relax, they must not think that we have done enough, now we do not need to do anything. For this purpose, judiciary has been strengthened with the PIL, and our democracy has become more deep rooted, more mature democracy. This is such a democracy that the entire world is having enough expectations, entire world is there, they have been following us, they have been getting so many things from world's largest democracy. Hope you must have enjoyed today's lesson. Okay, take care, stay safe, good day.